saw this and saw all the comments on social media, and honestly, internet is outrageous about Indian judicial system. But be that as it may, we'll deal and rather discuss very briefly about what has happened in this particular case. Before we start, understand fair understanding is very much important for fair criticism, and every case has its own merit and revolves around its own facts and circumstances. So in this case, trial court summoned the accused person for attempt to rape and attempt to penetrative sexual assault. Accused went to the High Court, challenged that summoning order, and High Court came to the conclusion that trial court was wrong while summoning the accused person for attempt to rape and attempt to commit penetrative sexual assault. Rather, the accused person should have been summoned for aggravated sexual assault under POCSO and assault or use of criminal force with intent to disrobe under IPC. We proceed further. Let's understand different stages of crime. First is intent. Second is preparation. Preparation, in some of the cases, preparation alone is offense. For example, waging war against the state. Third is attempt. Attempt is a stage wherein if there is no interference, the offense will be carried out by the accused person. And fourth is commission of the offense. So there's a very thin line of understanding between attempt and commission of the offense, which is interference. If there is no interference, the accused person was ready to commit that offense. So attempt is if there is interference, it could not be committed. But if there wouldn't have been any interference, the offense would have been committed. For those who think that High Court took the wrong view, High Court merely corrected the summoning order and stated that the accused person should have been summoned for other offense rather than attempt to commit rape and attempt to commit penetrative sexual assault. Yet, we can say that High Court could have taken a view wherein all of this would have been taken into consideration as attempt, but that particular observation or interpretation would have been very far-fetched, and in the eye of legal people, it would have been very, I would say, vast interpretation of attempt. For those who think that High Court was right and correct, the High Court fails to see that if there wouldn't have been any intervention, the progression of that particular crime is very natural. The crime would have been occurred, rape would have been taken place, and thus this particular act should have been an attempt to commit rape. Well, I've just gave you two perspectives to think upon and decide whether the High Court is right or wrong. Let me know what do you think about the same.